Hey, what's going on? What's poppin', y'all? I told y'all I'm from Alabama. We gonna say y'all. You're listening to the Off the Mark podcast with attorney LaConya Murray. Like I said, I told y'all I'm from Alabama, right? So Alabama's like home of the civil rights movement, Beyonce's daddy, and college football. That's right. So here's the thing. I'm not really into football. And up until like 13 years ago, I couldn't care less what was going on with football. I didn't care about no Roll Tide or no War Eagle. But I have kids. And apparently in Alabama, you have to draw your line in the sand like very early. I missed out on that because my folks were in the military. So I was not in Alabama for like the younger part of my life. So I have a child now who is a freshman at Xavier University. Big ups. And I remember her coming home her kindergarten, first day after kindergarten. She came home, she said, well, they asked me if I was an Alabama fan or an Auburn fan. And I said, well, what'd you say? She said, well, I said Auburn. And in my mind, I'm thinking, well, that's not really the right team because I went to UAB, which is a part of University of Alabama, you know, the whole Alabama thing. But I was like, okay. 8 years later, her sister comes home from her first day of kindergarten. By this time, I'm married to a guy who loves football. That's all he does is, watch football. Falls asleep to it, wakes up to it. And so my middle child comes home. She said, they asked me, Roll Tide or War Eagle? I said, what'd you say? I told them, Roll Tide. I said, okay. And then my baby, 2 years later, and I'm just telling you this so y'all can know how serious the people in Alabama take their football. So 2 years after that, my youngest child comes home from her first day of kindergarten. She said, Mama, they wanted to know if I was Roll Tide or War Eagle. I said, well, what'd you say? I said Mississippi State. Her dad is from Mississippi, and he is a big Mississippi State fan. I just bust out laughing. I couldn't do anything but laugh. That is totally hilarious to me. So we're here today. We're going to talk about football and trademarks. More trademarks than football, but it's okay. So former University of Alabama player and first round draft pick. I think he went number 11 in the draft. His name is Micah Fitzpatrick. He filed a trademark application for his nickname Fitzpatrick, and some people, they are big mad about it. They are upset. They feel like he is disrespecting one of the veteran players out there whose name is Ryan Fitzpatrick. And they believe that the trademark should be his and not the younger Fitzpatrick. So here's the thing. The younger Fitzpatrick, the rookie Fitzpatrick, apparently he's been going by this nickname since he was in high school. And the veteran has been, when he got drafted, I think he was drafted in like 2005. He used to go by the name. That's one thing you have to remember too. He used to go by the name. He's not really been called that recently until the new Fitzpatrick, or the rookie Fitzpatrick, has started using it. So I think they've kind of been seeing which one's the real Fitzmagic. And so what the younger Fitzpatrick did was he filed a trademark for clothing. He filed it just a couple of days ago. He filed it on the 12th. And so just so y'all know, this trademark application, once it's filed, since it was filed on the 12th, it's just going to sit in the database for 3 months until it's assigned to an examining attorney. And at that time, the examining attorney is going to look at the application to see whether or not he should be approved for a mark. So this is what we should be looking at, or this is some of the things that they're going to be looking at the application. One, they want to know how they're using the mark. So a lot of people are mad because they say that Ryan Fitzpatrick had the name first. It was a nickname, but that nickname wasn't associated with a good or service. Okay, so what the younger Fitzpatrick is doing is actually filing a trademark on the clothing. He said he wanted to file it for clothing and sell clothing when he was in college, but the NCAA rules wouldn't let him do it. And we know that the rules don't allow players to make money off their football skills. Only the schools can make money off of that. That's a whole nother story, right? So, and if you follow me on social media, we talked about it, I don't know, when we were talking about the Cardi B incident. Because Fitzpatrick, if this person that's examining the application is familiar with football, and so they're familiar with Fitzmagic, which is the trademark, and that it may refer to a person, one of the things they're going to ask them is, hey, does this mark refer to a person? And Fitzpatrick's going to have to say, yes, it refers to me. Now, that examining attorney will have to make the determination whether or not there's a conflict between the younger Fitzpatrick and the older Fitzpatrick. The second thing that you need to know about this whole application process is if the examining attorney doesn't see a problem with the application, it's going to be approved for publication. And doing the approval for publication, what's going to happen is it's going to give third parties an opportunity to object to the registration of this mark, meaning that they can say, hey, do not register this mark. We're going to be harmed in some type of way if you go forward with the registration of this mark. And this could be the time that if Ryan feels like he's going to be harmed in some type of way, this can be the time where he could actually object to it. Even though I don't think he's going to have to do that, because with all this drama that's been going on, people get keyboard tough. They do. They get behind that keyboard and they start saying mean things. And they were talking about him and his mom. He's just like, look, I did not know this was going to be such a big deal. If Ryan, who hasn't said anything about it yet, if he wants this mark, tell him to call my people and he can have it. Like, it's not worth all this. The third thing we need to know about this application is that he filed an intent to use application. So as we said before in the earlier podcast, trademarks are associated with goods or service. If there are no goods or service, then there's no trademark. There are cases where there are no goods or service yet, right? But you still want to go ahead and protect your mark. And in those cases, you can file an intent to use applications, which tells USPTO that, hey, I'm not using this mark yet, but I have a bona fide intent to use this mark. And so go ahead and process my application. And they will. They will process your application. You will get priority over anybody else that files after you, even if they are already using the mark, because you have let them know it's like a placeholder, except for the application actually does get processed. At the end of it, what happens is it goes through the same process, except for an approval, you get allowance, notice of allowance, meaning that, hey, you can use this mark, you're good. But what you have to do is once that notice of allowance has been issued, you have 6 months to show them that you're actually using this mark. And if you're not using it in 6 months, you can lose your trademark unless you file for an extension. And you can file for an extension every 6 months up to 3 years. And I think that intent to use applications are really good for people who are in the process of launching, but they haven't launched yet, and they want to make sure that all this money and time and effort that they're using to build and create this brand is protected. One of the things that I think about, there was a Airbnb, and this is another off this subject, but it's still relevant. There was an Airbnb. So we know Airbnb, but there was another company that was going to call it Airbnb. It was for people of color, because they said that at Airbnb there was a lot of discrimination. So you had one that was Noir, right? And then there was another one that was Noire. And for the longest time, like me and everybody else, we thought they were the same company. Come to find out, they were two separate companies. Neither one had filed a trademark. They went to talk to see if they could maybe join and work together. I guess the answer to that was no, because the next thing you know is one company filed a trademark for both marks, which they didn't have to do, because again, remember, trademarks protect not only same but similar. So even if they would have protected the mark that they were actually using, which is what they should have did, you can't get a trademark. You can't tie up trademarks. You can't tie up trademarks. I saw something on Instagram where this girl was like, I guess her and somebody else were going back and forth, and she was like, boom, I own you. I own your trademark. But you can't own a trademark. You can't own somebody else. If you're not using it, then that means you filed a false application. And so if the people aren't using the mark, there's no need of filing an application for it and tying it up. And we can go into that in another podcast. I know I'm kind of off of the subject right now, but that's one of the things I want you to know, that the rookie Fitzpatrick, he filed his application as an intent to use application. And that means that he's not using it in the market yet, but he intends to. So he's already said in interviews that he plans on using it as it relates to clothing. And I think that's a good idea. I remember one time there was a basketball player in Kentucky that was really popular, and he had this nickname, and I can't recall what it is, but I had a friend of mine call and say, hey, I want to trademark that name. I can tell this guy's going to be hot, and I want to trademark this name and be able to sell t-shirts on it and prevent other people from doing it. Now, what did we just learn a little bit ago? That you cannot file a trademark for a person unless you have their consent. But I think it's good for if you're going to do it and make money off of it. I think it's really good for you to go ahead and tie up your trademarks. That way you can have some control over how your name is used. But here's the big question. The big question that people want to know is whether Fitzpatrick, the rookie Fitzpatrick, can actually file this trademark. And the answer is yes, he can actually file the trademark. He is, because Fitzmagic, to some people, refers to him. That's a name that he's been using since high school. He's going to use it attached to a good. He's going to be selling t-shirts, so he can file the trademark. I guess the other question people want to know is, should he file the trademark? Should he file the trademark? And if the veteran Fitzpatrick has not been using the name Fitzmagic, which from my understanding, he was using it when he first came out and he was hot, and then it kind of just died down. And then when this new guy came in, they kind of just trying to see which one is the real Fitzmagic. So now we're trying to see, like, is there a conflict? Are people going to see Fitzmagic and think of the veteran, or are they going to think about the rookie? And I think that's a question, an answer that we're going to have to wait and see from the USPTO office. I think that if the veteran Fitzpatrick doesn't have a problem with it, and he hasn't said that he has, so this is a lot of times it's just the fans that are out there going through all this. And according to my husband who watches football, he says that up until just recently, nobody was calling and referring to him as Fitzmagic. So there we go. I appreciate you all tuning in and listening to the Off the Mark podcast. If you have a story that you see and you want me to talk about it, you know what to do. Send it to podcast@offthemarkip solutions. If you learned something today, you know what to do. I need you to hit that subscribe button, give us 5 stars, and invite this podcast so your friends can, so they can learn something too. We in business. We're trying to make sure that these brands that we're building, that we're not just building them, we're protecting them because they're assets. At the end of the day, it's not just about a registration. It's about everything that it allows you to do. All right, so that's all I have for you. You guys take care until next time.